everyone, and welcome to this, the fourth and final podcast in our series on AML regulation applicable to registered AIFMs. My name is Evelyn Marr, and I am partner and head of the Investment Management Department at BSP. I am joined here again today by my colleague Christopher Soterio.
Hi, Evelyn.
Hi, Chris. Last time we spoke about the type of information required by an AIFM when carrying out due diligence checks on investors in the funds that they manage and on any other counterparties they contract with. We spoke about how the information requested could be verified and the timing of the due diligence. Today we're going to look more closely at when and how AIFMs can perform simplified due diligence and when and how they must perform an enhanced due diligence. We will also look at the interaction of AIFMs with the Cssf on AML matters. So Chris, we know from the last time that we spoke that the AIFM should always perform due diligence measures on the investors in the funds under its management and on its counterparties. Are there, however, situations where the AML law allows the AIF to carry out lighter checks, perhaps on investors who present a lower risk of money laundering?
Yes, where the AIFM identifies a lower risk of money laundering and terrorist financing, it may apply simplified customer due diligence measures. In order to reach that conclusion, the AIFM needs to assess the investor or counterparty, taking into account things such as the geographic area where they come from and the particular nature of the business relationship. For example, whether we're talking about onboarding an investor in the fund for the first time, or whether the business relationship concerns the appointment of a new service provider, such as a new administrator to the fund or a depository or a broker. The AML law actually sets out examples of lower risk situations that the AIFMs need to take into account, and includes public companies listed on a stock exchange and subject to disclosure requirements, which impose requirements to ensure adequate transparency of the beneficial ownership of such company, public administrations or enterprises from countries or territories having a low level of corruption. And another example would be customers that are resident in geographical areas of lower risk, as determined by reports such as the report by the Financial Action Task Force that we spoke in previous podcasts. Even if the AIFM identifies a client or counterparty initially as having lower risk, it still needs to continue to monitor them so that it can detect any unusual or suspicious transactions or incidents which may occur subsequent to that initial assessment.
And even if an investor or counterparty is, for example, in a lower risk jurisdiction, is that enough on its own to apply a simplified due diligence?
I would say that just because an investor or counterparty is in a lower risk jurisdiction doesn't itself constitute a sufficient reason to just immediately apply simplified due diligence. The AIFM has to take a holistic approach and assess all the information for such client that it has before it. It will need to apply such lighter due diligence check based on a risk-based approach, based on the applicable AML policies and procedures that the AIFM has, and any other guidance given by the AML law, or, as we spoke before, or any other report by the international organizations.
Once the AIFM has identified a lower risk counterparty or investor, it can carry out a simplified due diligence. What does this mean exactly?
For investor counterparties that are themselves subject to a compulsory authorization or registration regime for anti-money laundering purposes, then a search by the AIFM on the official website of such regulator and documenting the results of the search should be enough, instead of asking from evidence from the client, for example, to provide them with an official extract from the relevant supervisory authority evidencing their registration with them. Another measure is the acceptance of other types of ID documents which meet the criteria of reliable and independent sources. For example, a letter addressed to the customer by a governmental body or other reliable public body where the customer cannot provide the usual identification documents, and insofar as there are no grounds for suspicion. For persons purporting to act on behalf of an investor or counterparty, where such persons are regulated credit or financial institutions, the AIFM can then obtain a letter confirming that they have applied due diligence measures to the underlying client and that they carry out regular controls on these clients.
And what about investors or counterparties who present a higher risk of money laundering? I assume there the AIFM would need to do enhanced due diligence checks.
Yes, the AIFM is required to apply on a risk-sensitive basis and has customer due diligence measures, in addition to the normal due diligence measures in situations which present a higher risk of money laundering or terrorist financing. Such situations include, for example, when customers are resident in geographical areas of higher risk as determined by reports such as the reports by the OECD or the Financial Action Task Force. Also, where customers are legal persons or arrangements that are personal asset holding vehicles such as trusts, or when customers are companies that have nominee shareholders or shares in bearer form, or when the ownership structure of the customer, if a legal person, appears unusual or excessively complex given the nature of such company's business. But in any case, the AIFMs should always apply and has due diligence measures when the specific transaction at stake involves high-risk countries or if they come across any politically exposed persons or PEPs.
What kind of additional measures should then be taken by the AIFMs when applying enhanced due diligence measures?
In such cases, the AIFMs can, for example, obtain additional information or documents on the source of funds or wealth involved by such investor or counterparty. They can request evidence on the reasons for an economic background of the intended or performed transactions and on the plausibility of these transactions. They can also verify the additional information obtained by using independent and reliable sources. They can even visit such investor or counterparty or contact them via registered letter with acknowledgement of receipt in order to verify their address. They can also increase the number and timing of controls applied and selecting patterns of transactions that need further examination. And they can update more regularly the identification data of such customer and their ultimate beneficial owners. For example, requesting for certification on documents such as passport or IDs of the customer by an embassy, a notary, a lawyer, an accountant, or similar, or even requesting annual accounts for the past 3 years.
You mentioned PEPs earlier. What exactly is meant by a PEP?
Politically exposed persons or PEPs are persons who are or have been entrusted with prominent public functions. Such definition includes heads of state, heads of government, members of parliament, members of courts of auditors or of the boards or directorates of central banks, could be ambassadors or important officials and members of the governing bodies of political parties, and it could be directors of an international organization. Where a PEP is identified, either in circumstances where the investor itself is a PEP, or where a person in the management of an investor or the shareholding structure of an investor is identified as a PEP, the RC is then required, in addition to the standard customer due diligence measures, to obtain the board's approval for transacting with such persons. The RC needs also to take reasonable measures to establish the source of wealth and source of funds of such person, and the AIFM must conduct enhanced ongoing monitoring of the business relationship.
We've spoken about the due diligence that the AIFM has to carry out. What happens if it comes across a case of money laundering or is suspicious that there might have been money laundering?
In such cases, the AIFM has to promptly inform the Financial Intelligence Unit, which is the relevant authority collecting information on suspicious or unusual financial activity from the Luxembourg financial industry, when they know, suspect, or have reasonable grounds to suspect that money laundering, an associated predicate offense, or terrorist financing is being committed or has been committed or attempted. In such cases, the AIFM has to submit a suspicious transaction report, and this should be done by the appointed RC of the AIFM. In order to comply with these requirements, the AIFM must be registered on the GoML platform, which is a digital platform set up by the state prosecutor of the Luxembourg Financial Intelligence Unit. In order to do so, it requires a Lux Trust token. This is to ensure that the AIFM communicates without delay their suspicions to the Financial Intelligence Unit.
In the event that the AIFM submits a suspicious transaction report to the Financial Intelligence Unit, how should the AIFM proceed with the concerned investor or counterparty? Does it need to refrain from dealing with them?
The AIFM must freeze its business relationship with the investor or counterparty in such cases and comply with any specific instructions from the Financial Intelligence Unit. If impossible to refrain from serving such person, the AIFM shall inform the Financial Intelligence Unit immediately afterwards. And where the instruction is communicated orally by the Financial Intelligence Unit, the AIFMs must expect that such instruction is to be followed by them by written confirmation within 3 business days. Otherwise, the effects of the instruction cease on the 3rd business day at midnight. And the AIFM is not authorized to disclose any instructions received from the Financial Intelligence Unit to the investor or counterparty without the express prior consent of the Financial Intelligence Unit.
And my final question, Chris, what are the supervisory powers of the Cssf, and what type of disciplinary measures can it take when an AIFM breaches its AML obligations?
In terms of supervisory powers, the Cssf can request access to any document to receive or take a copy of it. It can carry out on-site inspections or investigations and seize any document, electronic file, or other things that seem useful to ascertaining the truth. Also, it can require the communication of recordings of telephone conversations, electronic communications, and data traffic records held by the AIFM. The Cssf can request the AIFM to cease within such period as they may prescribe any practice that is contrary to the law and to refrain from repetition of that contact. In terms of sanctions, the Cssf can impose temporary prohibitions for a period not exceeding 5 years of the professional activities with respect to the AIFM, as well as members of the management body, employees, and tied agents linked to the AIFM. The Cssf may also issue a warning to the breaching AIFM or a public statement identifying the AIFM and the nature of the breach, or even fine the AIFM up to €1 million. In more serious cases, it can refer information to the state prosecutor for criminal prosecution.
Thank you, Chris. That brings to an end our series on the AML regulations applicable to registered AIFMs. I hope you've enjoyed listening to us. I hope you've learned something. If you have any questions, please don't hesitate to contact either Chris or myself, and you'll find our contact details on our website at www.bsp.lu. Thank you for listening.